Richard can stay. Judge Son.
Good morning.
Good morning, young man. How are you?
That's fine. That's fine.
Good. Glad to hear that.
It's Friday. We have to be fine. If we're not fine on Friday, something's wrong.
And we get a long weekend. How about that?
Good morning.
Good morning.
Staff. There's a prosecutor out here who wants to come in.
Yeah, they come in.
Oh.
Thank you. You have a packet? Good morning, Ms. Fitch. How are you?
Good morning, excellent. How are you, Your Honor? I'm just Shelley.
Okay. Shouldn't be too bad of a day.
There's a long weekend to look forward to as well.
All right.
Don't get my day on?
Yes.
Excellent.
So we have some customers already.
I'm with you.
Sorry.
Good morning.
Start writing. Waiting for my computer.
I'm sorry?
Oh, I'm sorry, I said I'm ready to start writing everywhere, I'm just
Okay.
waiting for my computer, so I'm all up. But, sorry.
Mr. Casser,
Good morning, Your Honor.
morning, sir. Who do you have there?
I've got Mr. O'Neill with me, Your Honor, for PCC, and we're going to be waiving.
Okay. All right, let me call him.
Good morning, Judge.
Good morning.
I'm here on Claude Lewis.
Hold on a second.
You ready to see?
Yes, ma'am.
Calling case number 2305-997801 for the state of Michigan versus Javier Ornelas. Defendant is charged in count 1, assault with intent to do great bodily harm less than murder by strangulation. Count 2, domestic violence. Second offense notice. Defendant has a habitual offender or offense notice.
Appearances for the record, please.
Your Honor, into your Spanish. Dinah Lynch on behalf of the people, P number 84589.
And good morning, Your Honor. Raymond Cassar on behalf of Javier Ornelas. Your Honor, he consents to this hearing over Zoom, and he's present with me, obviously, in my conference room.
All right, tell me your name for the record, sir.
Javier Aldon Ornelas.
All right, what's your pleasure, counsel?
Yes, Your Honor, today is the PCC date. I'm asking the court to allow us to waive the preliminary exam, knowing this matter will be bound over to circuit court. I've gone over that with my client, and he is in agreement.
Mr. O'Neill, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. You'll be bound over to Wayne County Third Circuit Court if you stand charged with complaint more. You understand that?
Yes, I do, Your Honor.
You understand the nature and the purpose of the preliminary examination?
Yes, Your Honor.
You understand if you were to have one, the prosecution would have to establish that the crime you charged with was committed in the city of Detroit, that was probably cause to believe you committed it.
Yes, Your Honor.
Is anyone forcing you to waive your right?
No, Your Honor.
Has anyone promised you anything?
No, Your Honor.
Are you waiving your right freely and voluntarily?
Yes, I am, Your Honor.
Any objection from the people?
No, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court criminal division for proceedings. Right on the information date, time will be February 1st, 2024 at 9:00 a.m.
March 1st.
I'm sorry, March 1st, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor. Good day, Your Honor.
Thank you. Have a good day, sir. Mr. Alex.
Good morning, Your Honor. We're ready.
Who are you here on?
I'm here on Brown, who is on Zoom also.
Okay, ready on Brown.
Calling case number 2405-549301 for the state of Michigan versus Reginald Brown. Defendant is charged in count 1, assault with intent to do great bodily harm less than murder by strangulation. Count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Dinah Lynch on behalf of the people, P number 84589.
Joseph Alex P 42284 on behalf of Mr. Brown, who is on Zoom. Mr. Brown, identify yourself, please.
Reginald Brown, 7/24/1987.
What's your pleasure, Mr. Alex?
Your Honor, we ask that this matter is set for a plenary exam.
All right, the court will continue to plead not guilty and set this matter for preliminary examination. How is February 23rd at 9 o'clock?
Judge, I'm out of town that entire week. I'll be back on the 26th, though, or on the evening of the 25th.
February 26th at 9 o'clock.
Judge, very much. That's wonderful. Thank you. Mr. Brown,
Yes,
February 6th at 9 o'clock.
thank you.
Okay, thank you.
what about my tether hours?
Oh, Judge, yes, Mr. Brown has another job, like some relief on his tether issues. Can we get a relaxation on the time or maybe a removal if possible in the tether hours? I'm sorry, Mr. Brown, I didn't mention it before.
He has another job where?
At the Milestone Grill, Judge, and he works until from 5 p.m. at time to 1 a.m. Other days he works from 11 to 5 p.m. So if he works till 1 a.m., Judge, we need it until 2 o'clock if possible, 2 a.m. Or just remove it. He's appeared here. He appeared last PCC. I'd ask just for removal, just for simplicity regarding Mr. Brown's other situation and work.
What's the name of the place he's working at?
Milestone, M like in Mary, ILESTONE, Milestone Grill.
Where's that located, sir? Mr. Brown?
9 Mile in between Gratiot and Kelly.
Okay, so what time do they close?
Your Honor, when I first made the request, we closed at 1 o'clock. And it's through the weekend. And I also promote, host, and DJ on
Here, let me
the
try it again.
weekends.
Let me try it again. I
So,
asked you
pardon?
what time they close.
Pardon?
What time do they close?
Well, when I host and DJ by about 2 a.m.
Brown, answer the question, please.
I said 2 a.m., sir.
Why does their website say it closes at 12? No, it opens at 12, I'm sorry.
Well, last week when I worked weekends, we closed at 1. I don't know if they're still in revised mode. It's a new thing, but last week I closed at 1. I have the schedule to back me up, and like I said, I also promote, host, and DJ at Club Echelon and various clubs throughout the metropolitan area as well.
What days of the week do you work there?
I work at Milestone Grill 5 to 6 days out the week. And like I said, I promote and host and DJ throughout the weekend. Friday, Saturday, Sunday.
They're not open any later than 12 o'clock PM or AM rather.
Okay, Your Honor. I understand. But like I said, I also promote, host, and DJ. I can give you my Facebook. I can give you the Club Echelon number, whatever else the court needs to check those resources.
So we were talking about this Milestone restaurant. Now you're talking about Club Echelon.
I informed Mr. Alex that I also promote, host, and DJ. I don't know why he neglected to I
Okay,
mentioned that.
It's all his fault. So how many
No,
jobs are
sir.
you?
It's my fault for being in front of the judge. So I'm not gonna blame anyone but myself.
How many jobs are you working? Do you hear me? Can you answer a
Yes, sir.
straight
I hear
question?
you, but for some reason, this Zoom is not loud enough, so I have to put it up to my ear.
How many jobs do you work?
2, sir.
So one is at Milestone. And the other
Yes,
is
Your
at
Honor. Yes, Your Honor.
now, if you're working, how many hours are you working at Milestone?
I work anywhere from 6 to 5 or 6, however many they schedule me. And when I work on the weekends, I go straight from Milestone to my events.
And that's at what time?
The events are from 9 to 2 in the morning.
But you're not gonna be there at 9, right? Because you're at Milestone.
Correct, but I'm able to come to my events late due to the relationships I have with the clubs, and other promoters be there to seat my people, my birthdays and things of that nature. As long as I'm there before the club closes at 2 o'clock, I'm in good graces with the clubs.
Who's your supervisor at Milestone?
The supervisor at Milestone is Liz or Victoria, and the general manager, his name is Val.
How long have you been working there?
I've been at Milestone since July of last year.
Do you have a phone number for him?
Yes, sir. Yes, sir. For the grill itself, or would you like the manager's number?
Both.
Yes, sir. Just give me 30 seconds, please. Milestone Grill's main number is 586-774-5000.
Okay. And the general manager's number?
My scheduling manager, her name is Liz. Her number is 586-371-3411.
All right, and do you have a supervisor at Club Echelon?
Yes, I do. I have 2 actually. One name is Candace, and the other is Mike.
Okay. Numbers, please.
Would you like Mike's number?
Sure.
His number is 810-824-0403. That's Mike at Echelon.
Okay. All right, people, would you like to weigh in?
Your Honor, I am, the people are not opposed to, people having gainful employment. However, the removal of the teller, I would ask that the teller remain.
All right, give me a second. I'm gonna come back to you guys. Ms. Soka, good morning.
Good morning, Judge.
Who are you on?
Mr. Claude Lewis III. We are here for the competency review.
Mr. Brown, I can't see you. I'm looking at your card.
I'm trying to fix it now, Judge. I had to put the camera up to my ear. I can't hear.
It's okay. You don't need to hear this. I'm on another case now. I just want to see. Okay. I'm sorry, Ms. Sophie, you say you're here on Lewis?
Correct.
Okay, we're ready on Lewis.
Are you staying?
I can if you need to, but I we're expecting someone else. So I'm happy to speak.
Okay, we don't have an APA here for that case yet, Ms. Sophie.
Judge, I have an 8:45 hearing in family court. Can I go back? Or how do we want to do it?
Sure, you can come back.
Okay, I'll come back. Thank
All right, thank you. I can't see you, Mr. Brown. Who you texting, Mr. Brown?
Say, I'm sorry, Your Honor. Can you say that one more time?
I said, who are you texting?
Oh, I was just letting them know that you were calling, just to make sure that they were woke and they knew what was going on, so they would answer the phone. You know, most people don't answer the phone when they see a number they don't know. So I was just letting them know.
Okay, Mr. Brown.
Yes, sir.
So tell me, what do you do at Milestone?
I dishwash, I bus, and I also expedite food.
How many days a week you work?
Anywhere between 6 and 5, 5 and 6.
Okay, and who's your general manager there?
His name is Valen.
Okay. And what does Liz do?
Liz is the what we call front of the house manager and scheduling manager.
Kind of interesting because I called Liz and when I asked her about you, she said who and told me I had the wrong number.
I might have gave you the wrong number then. Let me double check.
Give me the right number. Because then I asked her, I repeated the number back to her. She said, I don't know who that is, and I've had this number for 10 years.
That's
And then
crazy because I have text messages between me and her. She sent me my schedule right now.
I said, oh, you don't know Reginald Brown? She said, oh, yeah, I know Reginald Brown. I said, I thought you just said I had the wrong number. Then she said that she's the general manager there.
Oh. Well, Valen just bought the restaurant. Well, his father bought the restaurant. So I would classify him as the general manager. Liz is the standing manager. So I guess she would be, the general manager, but I wouldn't classify her of that. I apologize for the miscommunication. But she's the scheduling manager in front of the house manager. We just had a regime change. So I would classify Valen as the general manager. I have his number as well. It's not an issue.
The story sounded kind of fishy to me.
No, sir. Like I said, we just had a regime change. We changed the owners. Valen's father is actually the owner of the bar. So that's why I called him as the general manager.
Tethering hours right now.
I'm sorry, Your Honor. What did you say?
What are your tethering hours right now?
My tethering hours are 9 a.m. to midnight.
And that's not sufficient?
Well, not for my events, Your Honor. Like I said, I host, promote, and DJ. And just to be honest, I definitely need that extra cash, especially right now, to have to pay for this tether. I'm on child support, just regular daily things that is not your fault nor the court's fault. And like I said, I apologize for being in front of the court today, but I definitely have events and things that I would like and need to attend due to financial strains.
So you say you pay child support?
Yes, sir.
No, I know people in front of the court, right? I can call and verify that.
No problem, Your Honor. I actually have the letters right here. I'm looking at them.
Okay. So you're telling me you're working from 9 to 2 o'clock in the morning?
Yes, Your Honor, on the weekends and every other Tuesday. Yes, sir.
5 days a week?
I do my events on Friday, Saturday, and Sunday, and every other Tuesday. They put me at 9 a.m. because sometimes I work 11 to 5 at Milestone, as I did on Wednesday. I worked 11 to 5, and then yesterday I worked 5 to close, but I had to leave early due to.
Hold on, sir. They don't even open until 12. Why would you need to be there at 9?
Yesterday, I opened at 11 a.m. She scheduled, it's a swing shift. So
Yeah, but at 9, why you have to be there at 9 and they don't open until 12?
Are you speaking on Milestone or are you speaking on the events?
Milestone.
I don't know why the previous judge had it at 9 a.m. Probably because, like I told him, I work a swing shift at Milestone. I either open from 11 to 5 or I either close from 5 to closing when I'm at Milestone.
Okay, so I'll tell you what I'm gonna do. I'm gonna do 11 o'clock a.m. to 1 o'clock AM. Monday through Friday. Monday through Thursday, I'm sorry. Monday through Thursday,
So 1 o'clock PM or 8?
AM. And then on Friday, Saturday, and Sunday, from you don't work at Milestone there, because you only work there
Yes, sir.
5 days.
Yes, sir. Yes, sir. I work on the weekends at Milestone as well. So I
You
leave,
work-
I shut down the dish tank at closing, and then I leave from there and go straight to my events. Only
She told
thing
me
about,
week, sir.
say it one more time, Judge. I'm sorry.
You work 5 days a week.
Yes, sir. 5 to 6. Yes, sir.
So how do you get Saturday, Sunday in there? If you're working Monday through Friday?
Because some days I have 2 days off throughout the week, and some days I only have 1 day off throughout the week. So I definitely always work. Today, to be honest, I have an event today, and today is my first off day on a Friday since I've worked there since July. So they usually I'm mainly one of the strongest workers. So I work from 5 to close on the weekends at Milestone since I've been working there.
Well, I'm not buying that you're working 14 hours a day for one.
Your Honor, I work. I think you have it confused. I think you have it confused. So I work a swing shift, which means she can schedule me either from 11 to 5 or 5 to close.
Okay, well, you're gonna
You
have
get
to
what I
pick a shift.
like? Say that one more time.
You're gonna have to pick a shift that you're gonna work. What is it?
Your Honor, I guess I could tell her that, but she makes the schedule as she makes it. I don't. I either some a day or two throughout the week I may open, and then the rest I'm from 5 to close. That's just like yesterday. Just like yesterday, I had to open, which means I had to be there at 11. I'm sorry, Wednesday. I had to be there at 11 Wednesday, and I got off at 5. And then to yesterday, I worked 5 to close.
Continue. Bob, continue. Thank you.
Judge, what was the schedule, the tethering order presently? I'm sorry, I didn't.
Just stay in place as it was, because I don't know he's all over the place.
Thank you, Your Honor.
Your Honor, I just believe that you're not understanding what I'm saying.
Mr. Brown, I'll call you tonight. Let's not go there. It's not a good plan. I'll call you tonight. We concluded Mr. Brown's case, Judge.
Yes, we're all set. Thank you.
Thank you, Judge.
I see you're the one that art is the newest one. It's on pedestrian. I see, nothing that's true.
Good morning, how you doing? All right. You know APA Max Basil?
Yeah, that's the one on call.
She's in the
It's so good. It's so good.
I don't know. I've done here. Sure. I haven't seen it, so I'd like to see it for you.
Let's reapproach your moment. No, can't tell the difference. What percent? I've got. Show. Try to show. ma'am.
Did Ms. Schultz show up?
No, you are.
Faith Diana Shelley. Calling case 2455511 for the state of Michigan versus Faith Diana Shelley. Defendant is charged in count 1 assault with dangerous weapon, count 2 domestic violence. Appearances for the record.
Good morning, Your Honor. Diana Lynch, on behalf of the people, E number 84587.
Mr. O'Donnell.
I'm sorry, Judge. Good morning, Your Honor. James O'Donnell on behalf of Ms. Faith Shelley, James O'Donnell, P 42585. Madam, would you give his to the judge?
There's a date and time set for preliminary examination. Are people ready to proceed?
Yes,
How many witnesses for the people?
we have one.
Preliminary matters before you call your witness.
At this time, defense counsel was going to show me a video prior so that we could admit it in the session. I haven't seen it.
Thank you, Judge. I'm a little bit of good analysis. Maybe I have to check in with the 16 first. Well, Judge, it's not opening up here. I saw it this morning at home. It's not opening up here. It's not true.
Well, you can work on it, but you can call this witness.
All right.
Are you?
Your Honor, the people would call Mr. Martinez Henry to the stand.
Sir, please step forward, give your name and spelling of your name to the young lady that's waving to you over there. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you. Please have a seat in the witness box right next to me. Keep the voice up nice and loud and speak into that microphone so the people to your left once you sit down.
Good morning, Mr. Henry. Would you state your name and spell it for the record?
Martinez Henry, first name Martinez, last name Agnery.
Thank you. I'm going to be asking you some questions today, and anytime if you don't understand what I'm asking you, or if you need it rephrased, just simply ask, and I'll be happy to do so, all right? Thank you. Do you know someone by the name of Faith Shelley?
Yeah.
How do you know the defendant?
To my neighbor.
And is there anything else, have you ever been in, do you have a relationship with Miss Shelley?
Yes.
And what type of relationship have you had with Miss Shelley? Do you see the defendant in the courtroom today?
Yes.
For the identification purposes of the court, would you let the court know where she is sitting and piece of item of her clothing that she's wearing?
TL11, ready to be here. TL11, ready to be here.
You said it was a teal.
Said burgundy hair.
Thank you. Your Honor, please let the record reflect that the witnesses identified the defendants.
So noted.
Thank you, Your Honor. I would bring your attention back to the date of January 29th, 2024. Do you remember that date?
Yes.
Was there any different incident that occurred that day that brings you to court today?
Yeah, I had company and, she had a problem with that, so she came to my house with that.
Let's back up a little bit. What is the address that you were at?
7636 Legal, Redford, Michigan.
I'm sorry, what city?
Redford.
It was in Redford? And is that in the county of Wayne?
Yes.
Can you tell the court what happened on the 29th? You said that she came across the street with a baseball bat. She didn't like the company that you had. Let's break that down. What do you mean she didn't like the company you had? Was she at the house with you?
Yeah, so basically, I had company at home and she got the call and text of the bill I had.
How would Miss Shelley know that you had company?
She stayed across the street.
She lives across the street?
Yeah.
Thank you. And you said you received texts from her. What was that, what was it to indicate? What made you think she wouldn't like it?
So let me ask you again. Who stays at 7636 Beaver? And that's in what city?
Record, Detroit.
Sorry?
Record, Detroit, Louisiana, always know. Like right at the border.
Okay.
So you received,
So I stay in Redford.
If you just hold the mic, please, on your left, it comes up. Look, just take it up. Thank you.
I stay in Redford, like, it's like right at the border, so if you call the cops, either Redford or you go to Detroit, in that situation, it's Detroit that came. What does your mail say? Detroit or Redford? Redford. From mail comes to the house and said Detroit, my ID says Redford. So as I look up 7636 Beaver, it says Detroit 482. Right. But then like on my ID, it says, right.
thank you for the clarity, Your Honor. So you said you received a text message from the defendant?
Yes, she had texted me on 29th at 5:09, saying, I go outside and I see that B and another who was there coming in and out of your house that she pleases. I swear to God, I'm done. There's no point to be messing with you. I'm over it. Shit is hurtful.
So from that message, you indicated that the defendant didn't like that you had a female over at your home, correct? And what were you doing at your home at this time? Before the defendant came over?
I had just got off work.
And
I actually got here before I had got here.
and then what happened next?
She continued to call and text. And then at some point, I blocked her
So then she went to Facebook Messenger and started calling and texting me.
And were there any threats involved in the messages that you received?
Yeah, she told me I had till 6:30 to have her out the house, but she was coming over to work her back.
I'd like to go back. So then after you received these messages, what happened next?
I replied to a few of them, and I told her that if she came over there, I was gonna call the cops, but I couldn't do it, because I didn't have time for it.
So, then what happened next? Did the defendant actually come over?
She said, call.
Sorry, I didn't understand that.
So my question is, so the defendant said call the police. Did the defendant ever come over to the house?
Yeah, she did.
And was she invited to your home?
No.
Did she try to enter your home without your permission?
Pretty much, she was standing in between the screen door and the big door, so once I opened the big door, she was right there.
And then what happened next?
I pushed her out the house, and when I pushed her out the house, she stumbled back on the porch, and when that happened, she swung and started swinging back.
So what made you push her out the door if she was just standing right there when you opened the door?
She was like, if I didn't, she was coming in, and like I said, I had company. I wasn't trying to have somebody come to my house and attack somebody else.
Attack someone else? How would you think that she was gonna attack them if she just did in the house?
And she said, she texted,
She texted you.
yeah, to be exact, she did. Don't make me come F that new car up. And then I got my bag out the truck. I'm waiting to see if you're gonna have her leave or not. I'm not gonna try to today. I'm fucking ready.
Okay.
Sorry.
Oh, that's all right, so then when she came to the door, you opened it, was there anything in her hand or was she just standing there?
She had a black baseball bat. So
And what did she do with the baseball bat? Was it at her side?
initially it was just at her side, but once I pushed her, then she was swinging back.
Okay, and why did you push her?
She was coming into the house.
And did you say leave, you're not invited? Did you try to say anything like that?
I mean, everything happened so fast, like once I opened the door, it was like, damn, it wasn't a chance to say, hey, you go, none of that. I got somebody standing here in the living room, and I got one person coming into the house with a baseball bat.
When the door, did the person try to open the door or push the door open on you? Did anything happen like that? So if you opened the door, was there anything that was entered when you opened the door? Was the door helped to open, or did you just open it on your own free will?
But she was banging on the door, so I opened the door on my own free will. Like I said, she was already in the doorway.
And did you get injured when she was trying to enter in the house?
Not until she got the swinging back, and my foot was caught in the door. She hit me in the hand, side of the head with the bat.
So take me back through that. She opened the door and does she push her way in or does she just?
She was trying, like, so, the way, pretty much like the regular house, you got your big door, you got your screen door. If someone comes, they knock, and they're expecting to come in, they're standing in between both doors. As I opened the door, she was already standing on one of the legs of the door frame to come in.
And you pushed her, for what reason? Why did you push her? And someone was at the door.
So that she wouldn't, like, it is not like she knocked and then just opened the door and just pushed. She was standing there with the back trying to come in after already saying that she was gonna mess the girl up, that was good.
I see. Okay. And when you pushed her away, could you tell me about that? Could you describe what happened? Yes.
She stumbled a little bit and came back. And it was like she was using like her body to press up against the screen door, which is how I ended up messing up my foot. And from there, she started swinging the bat. The bat came through the screen. I don't have like the screen door It's like a half and half, so you got the bottom half, that's a solid part of the screen door, and the top half, it doesn't have the glass, it's just the screen. So when she swung the back came through the screen, she hit me.
Where did you say you were hit?
In my right wrist and left side of my head.
So you were hit twice?
Yeah.
At the back? Did you receive any medical attention?
No, it wasn't, like, wasn't no blood or nothing like that, just a little short.
And was anything else that you mentioned your foot got caught in the doorway doing anything with that?
Yeah, it was smashing the door. It wasn't broken or bleeding or anything, just swelled up. I was around for a couple days.
And how did you feel when you were struck by the bat?
I was mad.
Okay, were you afraid at all, or?
I wouldn't use the word afraid, but probably upset, yes.
So, yeah, you saw the medical attention you said earlier, right?
Correct.
Can you describe what the bat looked like?
Black, regular size baseball bat, wooden.
Wooden? And how did you eventually get away from her from hitting you with the bat?
I hit her, and when I hit her, she took off running off the porch, said she was falling out.
Besides the physical injuries to yourself, were there any damages to your home?
My screen door tore up, and the railings on my porch all tore up.
I'm sorry, was that the railing in your porch?
The railings, yes.
And did you get an estimate for the screen door?
Well, I looked something up on Home Depot, pretty much, basic screen door like $294.
And you said the railings were messed up. How did the railings get messed up?
From when I pushed it, she fell to the railing.
And did you try to repair the damages yourself?
Well, the only thing I did was I took the screen door off of the side door and put it onto the front door so that it didn't look so much up in the house.
Does it match exactly? Was it a good fit?
No,
Why
probably
not?
about 4 inches short. So I just used the 2x4 to make it up for the extra space.
So you were in a relationship with the defendant. Did you try to resolve this before you brought it to court?
Yeah, texted her and asked, I texted her and told her, no, I asked her, what did you want to do? I told her we didn't have to deal with no court stuff, but I'm not paying for my screen door to run out of my pocket. It's not everything wasn't right. So I told her just, you replace the screen door, rails. Problem solved.
No further questions, John.
Cross-examine.
Yes, Judge, I haven't managed to locate that video. Could I show it to Madam Prosecutor at this time? All right, Judge, thank you. Is it Mr. Henry?
Yes.
All right, Mr. Henry, have you ever been convicted of any crimes involving truth or dishonesty?
No.
Were you convicted in 06 of breaking and entering?
Yes.
Were you convicted in 07 of home invasion second?
Yes.
Were you convicted in 17 of the UDAA unlawfully driving away another's auto?
Your Honor,
Yes.
I'm sorry, what's this last one?
Unlawfully driving away another's auto.
I can't understand you.
Unlawfully driving away another's auto, I'm sorry. And in 17, were you also convicted of larceny by conversion?
Yes.
Did you tell the police she entered your house?
No, everything happened in the doorway. She was never actually inside the house,
So it's your statement, so she was never inside your house, correct?
other than being in the doorway.
She stood on the outside of your door, correct? You described, I'm sorry to interrupt, but you described there being two doors, and you're right about that. There's a screen door and there, you called it the main door, right?
Yes.
She never crossed the main door.
No, she was on the ledge. So you're standing between both doors. There's a small, probably 6-inch ledge.
Yep. She stood outside the house. She stood outside your door. She didn't go in the house, and she was talking to you, correct?
No, she was texting.
No, I'm talking about when she gets over to your house.
She got to the house, she banged on the door.
And you came to the door and opened the door.
Right. She was standing right there.
And then what did she say to you?
I'm not sure what she said. To be honest, if she said anything, probably about to yell and cussing.
And eventually, what you did is you reached out and you punched her, correct?
I pushed her.
You pushed her,
Initially, yes.
and she fell back.
Right.
And then she came back to the front door after you pushed her.
Right.
After she staggered back, she then came back, and then you reached out and you punched her.
Swung back and then I punched her, yes.
Judge, can I approach the witness?
Okay.
I'm approaching the witness. Left out video of the scene. All right, does this look familiar to you? Does that look like your house from the outside?
Yes.
Does that look like Miss Shelley?
Yes.
And that's a badge you've got in your hand?
Correct.
And it's, he's holding a little business down to the ground.
Correct.
At this point, she's walking over to your house.
Yes.
At this point, while it's not possible to hear it here, it's correct. At this point, she's knocking on your door with her back.
Bam.
Yeah.
Mr. O'Donnell, please keep your close up.
You see it? Yeah. The light just went on. That means you opened the door, correct?
Yes.
She's still standing outside. She's just been pushed down the steps,
Not down the steps.
back. She's come back again. I don't see the back being raised. Do you?
Go back a little bit, see that, that's the back.
I see her fist coming up from the doorway. She's walking away.
I don't see the link, just missing the whole part. Like trying to replace it, my. See the ground right there,
I see you grabbing the back.
saying that. Stop it, I got it.
So as a result of what you say, with dad strikes against you, you have to go to the hospital. You have any scars on your forehead right now?
Your Honor, I'd like to be clear that the video is only admitted for examination purposes.
That's correct. Has it been admitted? I haven't submitted it. Would the court like to see it? Only if it's admitted. I'll admit, I'll ask it in the objection.
Only for examination.
And that's defense exhibit what? I guess that'd be A. All right. Yeah, approach her. Okay. Just a moment, Your Honor. Judge, no further questions.
Can you redirect?
Yes, just for a few minutes, sure. You mentioned earlier that you received calls and text messages from the defendant. About how many of those did you receive during the day?
Judge, that was not the subject of my redirected examination.
Beyond scope, sustained.
The defense counsel was providing a narrative when you were watching the video. I was unable to determine really what he was saying, but you were correcting him. Could you tell me what you saw in the video?
Video speaks for itself. I don't need the witness
You don't? Thank you.
to narrate the video. You can tell me what happened.
Oh,
Not
so could you tell me what happened when,
As far as what happened in the video or what happened that day,
just what happened and then when she came to the door?
like I said, she came to the door, banging on the door. I got up, opened the door. She was standing right there, like on the door. And I pushed her out. When I pushed her out, she swung her back. I hit her. She took off back across the street and said she was calling the police.
And you also had testimony, or there was questions about your former mistakes in life, your criminal history.
Yes.
And have you made changes in your life to improve your, bless you, to improve yourself?
Yes, for the cases that he mentioned, he started all the way back in 2006, 2004 now. I did recently catch a case last year. For fleeing, basically not stopping on, I was on a motorcycle and got pulled over and they said I didn't stop immediately or whatnot. But as far as like catching cases like home invasions or B&Es or stealing their bikes, like all of that stuff, being 35 years old, kids, home, work, go about my day-to-day life.
So in 2006, 2007, how old were you?
17, 18.
Thank you. No further questions, Jim.
Sir, did you call the police?
Yes.
Why did you call?
Both.
And getting to this skirmish on your porch, did you take it back from?
I never took it out of her and it's not myself. Stop it.
So you weren't able to get it back from? No. Question based on my question.
Yes. When she came to the door, you grabbed the bat, correct?
No, that's outside the scope of your question.
No, it wasn't.
Oh, it isn't?
When she came to your door with that bat, what you did was to grab that bat from her and you had to struggle over that bat, correct?
No. I didn't touch the bat until the bat was being swung.
And did you grab the bat then?
I had my hand up, I grabbed like this, and she pulled back, the bat came back, and she swung it again.
What was she doing with the bat when you were punching her?
She took off. Yep, she didn't drop it, she didn't leave it, she took off.
All right. Thank you, Judge.
Okay, thank you, sir. You may start. Any other witnesses for the?
Not at all, Your Honor.
Any witnesses for the?
No, you're
People.
Your Honor, at this time. Your Honor, at this time, in lieu of the testimony, the people moved to bind over this defendant to the Third Circuit District Court and reserve argument.
Mr. O'Connor.
Yes, Judge. Again, I'm going on my view of the video. Court saw it, court can have its own view. My view of the video is I don't see the bat being lifted up by Ms. Shelley and swung at this person. I do not see her crossing the threshold ever. So that he's wrong about that. We also know that his credibility is in question because of at least 4 prior crimes involving theft or dishonest. Based on those factors, the fact that at least from one view, mine, I don't see the bat being swung overhead by Ms. Shelley at it. And I definitely see Mr. Henry swinging out from the doorstep, out toward her, hitting her while she's, excuse me, not on the threshold, not in the house, which she seems to want to claim she did. So for those reasons, Judge, I'd ask the court to dismiss this case.
Well, here's the problem with your client. First and foremost, that she goes over to confront the plaintiff witness. If she goes over there with the bag, why are you going over there with the bag? I would have to presume that you're going over there with bad intentions. That you're going over there with the bag. You feel like you have to arm yourself to confront them. Why confront them at all? Why go over there? Why not do as you allegedly said in your text message, leave him alone? So if he has so little respect for you that to bring somebody that lives there to his house, he lives directly across the street from you. He has that little respect for you, then that's not a person you should be dealing with. And you're a beautiful young lady. You don't have to deal with that. And now you're sitting before this court charged with a felony over that. So again, it's pretty difficult to see what was taking place on the porch, but I did see the light come on and it appeared, just like the witness indicated, that she stepped not all the way in the house, but between where the door would close. He indicated that he pushed her back, and as a result, she fell back. I did see it looked like she stumbled back, and then his testimony is that she came in with the back. So even if this is a claim of self-defense, so to speak, it's kind of hard to be self-defense when you initiate conduct in the first place. You went over there with the bat. You can't go and assault someone and then they respond in kind, then claim self-defense. It doesn't work that way. So the first mistake was going over there. The second mistake was going over there with a bat. What purpose? So the court, after hearing the testimony of the witness, is satisfied the people have met their burden of probable cause as it relates to the charges contained in the complaint of the warrant. The court finds those charges were legal in the city. The court finds probable cause for the and bound over to when it comes to Third Circuit Court criminal division proceedings. Is a random on the information date and time will be March 1st, 2024 at 9 o'clock. Thank you.
Thank you, Your Honor.
Okay. Ms. Soka?
Yes, Judge,
Are you ready now?
I am.
Ready on rules?
Case number 2305-792001. State of Michigan versus Claude Booth III. Defendant is charged in count 1. Homicide, murder, first degree premeditated. Defendant has a for defense notice.
Appearances for the record, please.
Good morning, Your Honor. Max Beisel, P77513 on behalf of the people.
Sir, not your turn yet. Go ahead.
Good morning, Your Honor. Daniel Lynch on behalf of the people, P84589.
Oh, I'm sorry, Mr. Basil. That's Mr. Basil's case. I'm sorry, Mr. Basil. Go ahead. Your appearance for the record.
Max Beisel, P77513 on behalf of the people.
Good morning, Judge. Rita Soka, P86239 on behalf of Mr. Claude Lewis III.
And what's your pleasure, counsel?
I'm sorry, I didn't hear you.
What's your pleasure, counsel?
My client is waiving his presence, and the last time we were in court, January 16th, we did not have a report from the Forensic Center. However, sometime that week, I did receive a report that was dated January 9th, 2024, which was his first 90-day report that states my client, Mr. Lewis, remains incompetent to stand trial. I did contact the Forensic Center this week, and I spoke to Dr. Portinga, which is the evaluator at the Forensic Center, and he stated that he remains, as of this week, incompetent to stand trial. However, they're not sending another report until mid to end of April, which is the second mark of the 90-day period.
All right. They found him not competent to stand trial, but restorable.
He is restorable as of this report. As according to this report, he is restorable.
You stipulate to those findings?
I'm
Yes,
sorry.
Your Honor.
I was asking if you stipulate to those findings, Ms. Soka.
Okay.
Is that a yes?
You're asking me or the prosecutor? I say yes.
Okay. The court makes a finding that the defendant is not competent to stand trial at this time. I'll refer him for treatment and set a review date, May 16th, 2024 at 8:30.
What date was it?
May 16th.
May 16th. Okay,
Thank you, Judge.
thank you.
Okay.
And that was 8:30 a.m.?
Yes, ma'am.
Okay, thank you. Have a good week.
Thank you as well. Ms. Schill. Good morning. Calling case 2061200, people of the state of Michigan versus Lisa Taylor Miller. Defendant is charged in count 1 assault with a dangerous weapon, count 2 assault or assault with battery. Appearances for the record, please.
Daniel, good morning, Your Honor. Daniel Lynch on behalf of the people, P84589.
And Alexander Cho, Your Honor, with the Neighborhood Defender Service, P85948, appearing on behalf of Ms. Taylor Miller, who was present in court. So you can just say your point.
Lisa Margarita Taylor Miller.
There's a daytime set for preliminary examination. Are you ready to proceed?
Your Honor, the people are unable to proceed with the prosecution of the defendant as the complaining witness is not present.
Your Honor, at this time, we request that the case be dismissed without prejudice.
So order, the court will dismiss this matter without prejudice. I need to dismiss the order.
So we have Mayor.
Mr. Mihas.
Yes, sir.
Come on up.
Yes.
Oh, Jones. Belt.
Doing well, how are you? Huh? Always. Good, thank you. Calling case 2356785, people of the state of Michigan versus Tyrese Martez Jones. Defendant is charged in count 1 explosives, sending with intent to crime. Count 2 aggravated assault. Defendant has a habitual offender for offense notice. He also has case 2356792, charged in count 1 weapons, firearms, discharge, enter in a building. Count 2 aggravated stalking. Count 3 assault with a dangerous weapon. Count 4 felony firearm. Defendant has a habitual offender for offense notice. Appearances for the record.
Good morning, Your Honor. Daniel Lynch on behalf of the people, P84589.
Morning, Your Honor. Gary Meehouse, on behalf of Mr. Jones, P number 66417. Tyrese, please state your name. Thank you.
There's a daytime set for preliminary examination in both matters. Are people ready to proceed?
The people are. I believe though this is a defense counsel that they call witnesses.
Your Honor, the people had subpoenaed officers. I don't see the officers we need. This is a continuation. These were the actual officers who were on site.
Their names, sir.
Second. Yeah, we were looking to bring in Detective Patrice Jones, Police Officer Bethany Gurney, and Police Officer Javanka Tyus, T-Y-U-S. In dealing with APA Shelley Drain, she said she had subpoenaed those officers. They were not able to appear last time. Now, my client was not here either because he had not been written out. He's in federal custody. It was my impression that people were working on bringing those people in. Some were sick, some were on leave, but nonetheless, none of them appeared. My understanding is we only have an OIC here. We don't have the actual officers who were at the scene who could testify to the evidentiary issues that were brought up at the initial hearing.
Was this matter held in part?
What's that?
Was this matter held in part?
Yes, Your Honor. And so it's somewhat awkward to see another APA. Right, Shelley Drain is the DV prosecutor. She is the prosecutor who held this beginning.
That was back on January 26th.
Correct, Your Honor.
And Your Honor, I was second chair, or I was in the room during that testimony. I've also been apprised of the matter. Shelley Drain says she sent out all of the subpoenas. And
Have you done any follow-up to see where your officers are?
actually, Shelley left yesterday and said she followed up with the officers.
Did any follow-up today?
Today, no, I can tell you. I've been in court since this one.
Your Honor, we're ready to proceed. If they're not here, I'd ask for dismissal of both cases here.
Your Honor, this says only, we're dealing with.
It's not grounds for
Yeah.
dismissal, sir. So. Court can show cause those officers to explain why they have not honored the court's subpoena. I need their names again, and their present sign.
Yes, Your Honor.
You say you have an officer in charge here, is that? Are you the officer in charge?
I'm sorry, is this on the Tyrese Jones case?
Yes.
Okay, I am Detective Burns. I was here for the last court case, and as we discussed the last time, there were two cases that were handled, and so I was in charge of one case, and we do have OIC Zakowski, who the defense counsel did request to be present to reschedule the court date. He is here.
Okay, and that is on the first case, Your Honor. That is on the other case. However, my understanding was that Bethany Gurney, Police Officer Bethany Gurney, and Javanka Tyus on the explosives case, who the OIC is the OIC of, are supposed to be here. And they were the ones who were actually at the scene. And there was a lack of evidence that's been presented of the actual crime. There's nothing in their police reports that indicates any of the events or the descriptions or the evidence that the complaining witness testified to was actually gathered or seen by the police officers. And so we asked for a continuance, you granted it, so that we could bring up impeachment evidence, as well as not having the actual body of the crime in evidence in this case. That's why we continued it. This is now the second time that we're about to continue it. If you want to show cause of two officers, that's great, we can do that.
Did you know of these other officers he was requesting of?
No, Your Honor. The officers that was requested on that day, the names that I did write down in court was the OIC, the original OIC, which was Zakowski, and the defense counsel said Ms. Wash, Officer Wash, in which I believe she's on furlough. And those are the officers that Shelley I'm sorry, the APA challenge.
During,
I'm sorry, okay. APA Dre, sent me this appeals for it as well.
Your
so when
Honor,
did you make it known that you wanted these other officers to talk about?
Your Honor, I made it known that day, and I've made it known in, following discussions with Ms. Green. And we made it known in the last hearing.
Did you have anything in writing?
I have emails, so I don't have them with me, Your Honor, but I've been, or
You
text
can't
that I've
access
got.
your email?
What's that?
You
No,
can't
I can't
access
on
your
my
email?
phone right now, no. But Your Honor, I've been in discussions with Ms. Green, and the record is reflective of the lack of evidence presented, because we had the OIC on the stand in this case, and she indicated none of this stuff was in evidence, but she
So
was
why do you
not
need
at the
these-
place.
Why do you need these other officers?
You asked for them, Your Honor, because
They
they were.
didn't ask for anything, it's not my case.
Well, Your Honor, I have to continue the case because you weren't necessarily satisfied because the OIC was not there. The actual officers were there, and so you wanted, this was implied, you wanted their testimony.
Okay, let's try this. Let's say in lieu, because of these circumstances, let's say in lieu of the officer's testimony, have people stipulate to their reports. Is that satisfying?
No, Your Honor, I would actually want the officers here.
So why wouldn't their report satisfy? Because that's, let's say, for the sake of argument, that's all they're going to testify to, is listen to the reports.
Your Honor, the last time, that may or may not be true, Your Honor, because often police officers testify outside of their reports, and that may be a risk I'm taking. But it's been my experience in 20 years that they're not necessarily confined to their reports. But if we're gonna go through their reports, what we see is that there was actually no evidence gathered in this, including what appears to be a rock.
So they stipulate to that. Now what?
Your Honor, we want the officers to come in.
Okay, well, he'll be held down here in Wayne County Jail until that happens.
You understand that?
Okay.
So we have new, so just like, do you have a list of the officers that you want this time? And you can send them to Shelley, bring it to myself.
I will send you guys,
No,
yeah.
it's not again, it's like original.
I sent it to Shelley Green. I wasn't aware that you were the second chair. That wasn't made known to me during the hearing.
But, the other point I want to put into the record is that there was evidence, it was testimonial evidence, it's also photographs that the witness had.
I saw it. I remember.
And none of which were given to the police at
Yeah.
the time this happened. And when this went through, the photographs, the videos were presented the day of, so we have no foundation as to when that video was taken or why the police didn't gather it. It is important in this case, Your Honor. If we're gonna have police investigation and the prosecutor's office is actually gonna charge a warrant with no evidence that they gathered in their evidence bins, in their, chain of custody, we have none of that. What the prosecution is saying is a person can come in here the day of the prelim and hand over video and say, we've got evidence. And now we're going to find over because that's probable cause in and of itself. I absolutely disagree with that. I don't have the case law, but I have never envisioned or experienced anything like that. Because if we're gonna go by the police report, there is no documentation of taking any of this in evidence 2 years ago. Why that didn't happen needs to be explained.
Your Honor, I would speak to a couple of things. Often when we get into a preliminary examination, we don't have a lot of evidence. And during defense counsel's statements last time, he was requesting fingerprint evidence on the brick, which, as we all know, you can't garner.
Your Honor, that's not true. I never mentioned fingerprint evidence. I will refer to the record, Your Honor. It was not asked.
Hold on a second, let her talk.
Okay.
So on the YouTube video and when I was sitting in court, it was very clear that he was asking and challenging that there was no fingerprint evidence on a brick, which it was a brick that was put missing. We saw a photograph of it. Oftentimes people come in here with their cell phones, they have evidence and they bring it in. So there are many cases I've said in my short life here, where I've seen witnesses bring in their cell phones, they have videotape that they haven't shared with the police, and they bring it in and they show it, and it's been admitted for examination purposes only to the court. And that's happened on most cases I've said. So this is not a trial, it's probable cause. The witness testified to it, and her testimony is indeed evidence.
Your Honor, if I may, I'll say to the record, and we can pull up the transcript, we can pull up the recordings. I never mentioned fingerprint. I mentioned actual evidence on a crime that was committed November, or allegations that it was
I'm not
committed.
so much concerned about that, sir, as I am as to who you communicated that you want. I recall you saying that you wanted the original officer.
Shelley Green. Your
I
Honor,
don't recall you mentioning all these other names.
Your Honor, Shelley Green, and that was mentioned the last time.
I'm talking about on the record. I don't recall you mentioning all those other names.
Your Honor, there is no body of the crime. What the government did not say is, we don't have any of that. We've had 2 years to get ready for today, and we still don't have any evidence. We had this back in January. In that time, they still don't have any evidence. When I raised all of this last.
Sir, I don't want you to lose sight as to what we're doing. First of all, this isn't the trial. You need all these other witnesses to come and say that we didn't collect what, a Molotov cocktail or brick that was lying in the sink.
Or ashes, or any indication.
Why do I need to hear that from 4 witnesses?
Because at that point, Your
I
Honor.
need to hear that from all 4 witnesses. If it wasn't gathered, and I think people are willing to stipulate to that, if they didn't collect that, then I don't need to hear from 4 witnesses to tell me they didn't collect.
It's impeachment of the 1 witness you have.
Yeah, I don't need 4 witnesses to testify as to impeachment.
Your Honor, I do need to make a record, so if you do bind over, I can go to the next court.
I
and file a
understand that,
motion.
but you're not gonna call 4 witnesses to tell me the same thing.
I just want one of the people who was
Okay,
there.
so why can't you use the 1 witness that we have here today?
We had her on, and that did not
That's not
satisfy
the
you.
witness I'm talking about. You have the original officer in charge here, and she said there's another officer here as well.
On a second case, on the other case.
Do we have any witnesses here on the case involving the explosives?
No, sir.
All right. And the witness that you want is who?
Your Honor, I want Bethany Gurney, who's the arresting officer, and Javonka Tyus, who's the arresting officer. They were the ones that went to the scene. They
Why
were,
do you need both of them?
we can have one or the other, Your Honor.
Okay, one of the other. And Ms. Drain will be back when?
In March, March 4th.
But I'll be vehemently state, Your Honor, at no time did I ask for fingerprints on a rock.
Why are you still talking about that? I don't care. about
Because I'm offended by it, that's why. I'm making a record.
You
There is no time that I do
Not on
that.
my time.
Okay.
March 4th at 10 o'clock.
Second. Okay, Your Honor.
All right, court will continue this matter on March 4th at 10 o'clock. Officers, let's do everything that we can, or whatever it is that we need to do to keep the defendant here, that they don't send them back to MGOC, so we have to get them back out.
It would be federal custody.
Or federal.
No, I just don't want them confused, go man to go see him, and
Okay,
they got the wrong agency.
whatever. We can.
That's maybe the officer in charge of state. Yes. Patrice Barnes, P-A-T-R-I-C, Barnes, B-A-R-N-E-S, detective.
Mr. Buttar, how you doing?
Good morning, Judge. I'm doing well. Thank you.
Good. Okay, let me ask this, as it relates to the officers that are here on the second case, we can resolve that now. Let's do that. So calling case 2356792, People versus Tyrese Martez Jones, defendant charged in count 1 weapons, firearms, discharge, injury, good. Count 2 aggravated assault, count 3 assault, dangerous weapon, count 4 felony firearms. Defendant has additional experiences.
Good morning, Your Honor. Diane Lynch on behalf of the people, P-84589.
Morning, Your Honor. Here again, on behalf of Mr. Jones, P number 66417. Tyrese, please state your name again.
All right, so this matter was held in part on January 26th to February 2nd, adjourned on February 2nd to today's date. And are we ready to proceed?
Oh, we are, Your Honor.
Yes, Your Honor.
So I guess it's on you, Mr. Jones.
So please have Officer Zokowski, please take a stand.
Mr. Buttar, do you have witnesses on your case?
Yes, sir. Judge, I didn't get a chance to ask the question.
Do you have witnesses on Belton?
Your Honor, we do not.
Okay, let me do that real fast.
Yes, Your
Honor. Just 1 second, sir. Calling case 2455513, People of the State of Michigan versus Wayne Belton Jr. Defendant is charged in count 1 assault with intent to great bodily harm, less than murder by strangulation. Count 2 domestic violence, 30 minutes. Appearances for the court, please.
Good morning, Your Honor. Diane Lynch on behalf of the people, P-84589.
Good morning, Your Honor. Daniel Bazar on behalf of Mr. Belton, P-62191.
Mr. Belton, tell us your name, sir.
Daniel Belton.
There's a date, time set for preliminary examination. Are you ready to proceed?
Your Honor, the people are unable to proceed with prosecution of the defendant as the complainant witness is not present.
Your Honor, we move to dismiss at this time.
So order the court will dismiss this matter without prejudice. I just need to dismiss the order.
Yes, Your Honor. Thank you.
Thank you. Okay, we're back on the record on People versus Tyrese Martez Jones. Witness, please step forward, give your name and spelling to the court reporter to see over here. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, sir. Please have a good response. Maybe game when you're ready.
Morning, officers of Belton. How are you? I'm very good. Thank you for coming in. Do you recall the events of December 3rd, 2022? And at that time, were you called out to a home on 184 or 18473 Common? Yes, sir. And you got there, you arrived, you saw a complaining witness, correct? Correct. And she complained about gunshots being fired at her house?
Yes, sir.
But it wasn't fired on that, is correct?
Not that, no,
It had been fired a day or two before,
in my last night, yes, sir.
and so it's more than 24 hours. Had expanded since the firing of those gunshots, alleged gunshots.
I believe so.
And at that time, she complained that she saw someone that she described as Mr. Jones,
Yes, sir.
and she gave you a video.
She provided, security camera footage, yes, sir.
Okay. Did she provide any of any text?
She, there was social media posts that she provided.
And did you give that to the prosecution?
I was uploaded, I was like,
I'm sorry, it's on
to evidence.com.
the.
Yes, ma'am.
Now, you reviewed that video, correct?
Correct.
You make out the facial details of the person in that video?
It was blurry, but facial details were blurry.
Okay. And you could not tell whether that was my client or not, correct?
I was not able
I
to.
don't think it's proper to ask the officers to make identification video. You wouldn't want to say that positively that that was your client. It works both ways.
I agree, and I took that chance and he said it's not.
It's not, you can't proceed in that fashion, sir. That's what I'm telling you.
You could not make out anybody on that video, correct?
You could see a person, yes.
And you took that into evidence, correct?
Yes, sir.
From your observation, were you able to gather any, shotgun or, shell casings in the area? Did you gather any shell casings?
I did not know, sir.
Well, did you observe any bullet holes or any, any damage to the house from, bullets?
There was damage to her property, yes, sir.
Okay. And were you able to ascertain if that was recent or had been there for a while?
She stated it was from this,
Were you able to ascertain yourself
as into which,
as to whether it was, damage that had been previously done or had been done recently?
I could only base it off of what I was told by the detectives.
Did you bring any kind of, firearms or, ballistics personnel out there to evaluate this?
No, sir.
Nothing.
Cross-examine.
No questions.
Sir, are you in evidence there?
No, sir.
So you don't collect evidence?
I can't collect evidence, sir, but I know evidence.
Your Honor, if I may follow up?
Go ahead.
Were you finished with your questions?
Yes.
So you were the officer in charge on the scene?
Yes, sir.
It's your responsibility to bring out evidence text?
If there is evidence to be collected, yes, it can be ordered to see.
Were there pictures taken by you or an evidence tech of any damage to the home?
There was no pictures taken by me, and I believe evidence text, but I'm not 100% positive.
But you testified earlier that you did not ask for evidence text to come out.
You asked for ballistics. Officers, we don't have those officers, sir.
Did you bring in any evidence text?
I believe so. But I'm not 100% positive, sir.
Now, do you need your report to review?
Yes, sir.
You don't want to read it.
This is not my report, sir. This is Officer Evans and Bush's. Should be.
This is also Officer Eric Smith. Did you work before? Yes, sir.
In reading this refresh your memory as to what evidence was gathered or
Your
not.
Honor, objection.
Your Honor.
This isn't a reflection of his own.
It doesn't have to be. Anything can be used to refresh our collection.
Thank you.
Officer, does that help in refreshing your recollection?
This seems just to be the arrest of the offender.
So it doesn't refresh your recollection?
No, I apologize, no, sir.
Did you actually do a report this case?
Yes, sir.
Refresh your recollection by any evidence was gathered or not.
This will not be also still arrest.
When you do a report, in this case, you weren't at the scene, correct?
Your Honor, objection. This is going to be on the scope of your question.
Your Honor, it's still within the scope in terms of whether evidence was collected, and in that case, how he came to conclude whether he documented whether evidence was collected.
The defendant has already stated that he's done a report.
And I'm asking about
Or the
that.
defendant,
Your
I'm
Honor.
sorry, the witness.
I'm asking about that. In the course of doing the report, I asked,
Go ahead, Mr. Beal.
were you at the scene?
I was at the scene, yes, sir.
And as you do your report, do you review the reports of your officers who are there with you?
For the investigator's report, yes, sir.
Okay. And in reviewing these documents, those were the reports of your officers who were at the scene, correct?
So for that incident, was the arrest of the defendant, I was not in charge of the arrest. I was in charge of the shots fired.
Were you at the scene?
I was at the complainant's home where the incident took place, yes.
And to your recollection, you did not collect any evidence,
I
correct?
personally did not collect evidence, no, sir.
And you did not get any evidence from evidence technicians, correct?
I believe photographs were taken.
And nothing further. And 1 second, I'm sorry. And you don't have a copy of your report here with you?
No, I did not, sir.
And so it's your testimony that when you come to testify for a crime that was committed 2 years ago, you go by your recollections and not your report?
Your Honor,
Argument is sustained.
And Your Honor goes towards the basis of his knowledge
I
and
sustain.
police practice.
Argument.
Nothing further.
Thank you, sir. You may sit.
Your Honor, as to this charges in this crime, or alleged crime. What we have are the allegations of someone who claims.
Let's do this by the book.
Okay.
People, you, have a motion.
Yes, I do, Your Honor. The people would request, based on the evidence from today and last month in January, that we find the case over for the Third Circuit Court, and I will reserve arguments.
All right, go ahead.
Your Honor, what we have to base that on is the testimony of someone who may not be telling the truth based on both cases. We took collective testimony.
Let's cut to the chase. Tell me why this wouldn't be a question of fact to be determined by a trial.
Because you still have the duty to be a gatekeeper. And when you see someone whose testimony is not credible, you have a duty to keep them out of the Third Circuit, to not find there was question of fact and no question of fact. It doesn't rise to a level of probable cause because the sole witness they have that says anything is relying on a video that the officer says you cannot identify who that is. Looks at it, says, I can't say who it is because it's so blurry. That in and of itself makes her testimony not credible. Your Honor, can I please finish? As we're going on and she's telling stories that are inconsistent, she's waited a day to 2 days, officer testified, at least 24 hours before she reports any of this, to say, my client was there. Not afraid, not, you either report or you don't when you're afraid like that. Again, it strikes towards credibility. When the officer says, I don't know if there was any evidence yet, can't tell you, he thinks there was, doesn't bring a report in on a crime that was committed or allegations of a crime that was committed 2 years ago, but just speculates. Yeah, I think so. The people have not done enough to come to this court and say, there's probable cause. I understand it's a low standard, Your Honor, question of fact, but it's not such a low standard that the people can just come in here and just throw something against the wall and say, you see, question of fact. When the video that they rely on is blurry and that person cannot testify credibly to it, when a trained officer with years of experience is looking at it saying, it's so blurry, you can't say who it is. And when cross-examined, she says, I just know. Has no explanation. I'm just know. You can't say that we have any body of crime here. None of the pictures were presented to this court. None. To prove any gunshots, anything like that. None of that was brought here. Somewhere in the ether sphere, maybe it exists, but it doesn't exist in this court. And to say it does and not have it, that's not probable cause, Your Honor. That's question and doubt. That's a question, I get it, question of fact, but it's such a question to say if it's not here, it doesn't exist. And so when we go there and we say, you know, firearms discharged in a building, and all we have is a video of somebody on the yard that was reported a day or two later, you have to question that to the point that the prosecution has not made their case. And you can step in as a gatekeeper and protect the court above from a case that has not been proven. Along with that would be count 3, assault with a dangerous weapon. Along with that would be count 4, weapons, felony firearms. Along with that would be count 2, aggravated stalking. Because to say that he was there and not be able to prove it, not be able to show it, only rely on a shady video where you cannot identify him, but not bring in any other video, any other pictures, any other proof to collaborate what is shaky testimony that in the grand scheme because we heard both cases, she started adding things in the other case, which also made her not credible. All this testimony about the prosecution's choice was taken all at once. And in that case, her testimony was not credible. Because we saw no char marks, we saw no ashes, we saw nothing to collaborate. They brought nothing to collaborate that testimony. And so overall, you don't have enough. Not my fault, not your fault, their fault. They had 2 years to prepare for this, 2 years to bring people in, 2 years to bring evidence in, 2 years to bring pictures in, ashes in, to take texts out there to find out what happened. They didn't bring it. They just put the shaky testimony of a person who decided maybe a day or so later, I'm gonna call, with no foundation where that video came from, with no date or time, no timestamp on it, nothing. And so for that reason, Your Honor, question of fact, I admit, that is a standard. But you still have that level that you have to determine. Could a reasonable jury look at this even from a probable cause standard and say, you know, it favors the prosecution? No, not with the lack of evidence that they presented, and not with the shaky grounds that the little evidence that they presented.
You started to repeat yourself.
That's why I finished. Thank you.
The phrase shaky testimony was used several times from the victim. The victim stated when she watched her own video, and it was questioned about it, she said, I know it's him. I know what he's wearing. I know how he moves. She could identify his entire physique. She also stated, I found her testimony to be very credible. In the fact that she was able not only to state that
Nobody interrupted you, sir.
She's vouching for.
Nobody interrupted you.
Excuse
You
me.
have valid objection.
Let's say objection, so I know what you're talking about. I don't need to speak for objection.
Objection, Your Honor.
Legal objection, legal objection.
Objection, she's vouching for the testimony. She's not allowed to say, I'm credible. That would be vouching for it. That's not part of the analysis.
Just saying.
As far as her testimony, this is an argument or a trier of fact. Not everything has crystal clear video like we see on television. This is a case where it is a determination between what the testimony is offered and whether or not it is credible. And that's a question of fact for the juror. The evidence itself to determine credibility is, you're right, it's not my decision, but it is for the trier of fact. Also for the video, and the video was not the only evidence that was offered. We also gave testimony. So there is quite a bit that was offered. That's all. Thank you, Your Honor.
If I'm not mistaken, I believe the witness didn't just testify as to seeing the video. She said that she actually saw.
Yes, she did.
the defendant
Yes.
leaving from the scene after the shooting took place. I didn't find anything inherently incredible about the witness's testimony. She appeared to be a very credible witness, and her testimony is supported by the video, people's video that was entered into evidence. She indicated that not only was she able to tell how he moved, how he looked, and that type of thing, she knew, she was very certain that it was in fact the defendant that was firing shots. And who else is firing shots? I don't care if she reported it a day later or a week later, it's undeniable that somebody was in her backyard firing shots at her house. Officer testified here today saying that there was evidence that the house had been fired upon. She testified that the house had been fired upon. And in addition to that, she testified this defendant harassing her over a period of time, consistent with the actions that allegedly took place on that day. The court has no issue in finding this matter over, finds that people have met their burden of probable cause as relates to the charges contained in the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be February 23rd, 2024 at 9:00 a.m.
Thank you.
So.
So we're gonna meet him back on March 4th.
Right.
Can we do whatever we can to make sure he doesn't get sent back to federal authorities? What you need for me, for him to put a hold on, or what? Well, I know he won't be going anywhere for at least a week, because he has to be arraigned over a circuit court. But beyond that, we need to try to see if we can keep it here.
That's not a given, because wasn't there a week after another case that I had.
Really?
That's not.
All right, well, we'll try. That's all we can do.
I know.
If you get information that he has been sent back, let me know so we can get it written down and get it back here.
You know, thank you for your patience.
Thank you, sir.
Thank you for letting me turn.
Yes, sir, I do my best. All right. Yes, we are. Okay. So this is. And 3:00. It'll take. I should. This week. Okay. Hop on.
Yes. Understand?
Yes.
Just tell me. All right, well, you already. Thank you. I was told that they were Christian, and we had done it here, but I was told that they were Texan. So I was in that. Otherwise, I'd go home myself.
Thank you, sir.
Uh-huh.
Brief. I thought was about this issue with this camera. So I told her we would put it over to Tuesday.
So the Jones case is going to be March 4th. And that's an indicator you have something. In your system, has it already been added or do I need to? Listen, thank you very much. I was gonna get out those subpoenas when I was reading. Oh, okay, yeah, I was just. Thank you so much. The lady doesn't test too much. Yeah. So. That I said. Previous time, that there was no fingerprint done. And the overall, right? So today. How do I know there's? Because I guess this is, but then. Yes, that's right. Well, Shakespeare goes a long way. Getting into the long weekend. Oh. Right. There's so much. I had a small place over on the other side of the state. And that was, I saw that. Somebody over there. Yeah, off the, well, it's not, I'm late. It's a little bit. And it's just so nice. It's like getting away from the home. I like counting that. Take me away. I say, I hope that is. I hope so as well. All the way to straight across the 96. You're just straight across the other side. There's just cute little town, there's a lot of little buildings and those areas. Little different cities. It's south of Holland. Not too far south.
Attorney has filed a motion to change. What's happening? Probably should do what they do. Probably.
I can't see that maybe it's released.
But we talked about.
That's true. It's definitely the question of the text.
They might come next.
That's what she should have done. That's not what she should have done.
No, absolutely.
We should thought of them. Verdict for
I think he does. Actually. To exclude, so it's a photograph.
Not only that, I felt because it was a different shoe of the box, the safety of the box. Right. Very sad. Not only that, the jury that we heard this case probably is heard very other information. He's charged with what, second? Thank you, sir. Friday, right?
It is.
Gentlemen.
Are we doing the
How you doing, brother Kyle?
we doing the case up?
Yes, sir.
Are we doing the case up?
I have one after you, but you're next up. Are we ready on Culberson? Calling case 2455512, people of state of Michigan versus Fred Bowman Culberson. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation, count 2, domestic violence. Appearances for the record.
Good morning, Your Honor, to your staff. Dinah Lynch on behalf of the people. Key 84589.
Good morning, Judge Michael Copy, 78658. I'm here on behalf of Mr. Fred Culberson. Mr. Culberson, would you state your name for the record, please?
Good morning, Your Honor. My name is Fred Culberson, Culberson.
May I please go on the court? Good morning.
Good morning.
Good morning. Today is the date time set for preliminary examination. Are you ready to proceed?
Your Honor, the people are unable to proceed with the prosecution of the defendant as the complaining witness is not present.
Your Honor, defense will move to dismiss.
So, we'll discuss this matter without prejudice. I see that this matter is scheduled for 11:30. Do you not anticipate your witness being here?
I do.
Okay. Dismiss without prejudice. I need an order.
Thank you, Your Honor.
Okay, thank you, sir. Have a good day.
You as well.
All right.
I was awaiting a copy of the order. I was awaiting a copy of the order.
Okay. Okay.
You take care, have a great weekend.
Thank you. What was that? A year ago. I think it was, you set up for their hearing, right? Was it? Yeah. it wasn't. So we could have set up for their hearing.
Excuse me, Judge. Brian? Am I trying to take a copy of the dismissal to Dickerson or Ted?
Yes.
Thank you.
Now, the one that was waived was the second one down. As, so, under, supposed to be the first one, yeah, I think the first one. Was killed. Yeah. You're welcome. What's in? Yes, yeah. No, I just have a dog. I have a little boy with fur coat. But, yeah. She's very nice. Yeah, that's right, just, but it just got to go. And that's what I did today. I know it. Are you here? But it just depends on the picture. Right. Yeah. I see. This is the defense attorney kept saying, oh, objection. They- Oh, I thought you were feeding them. Recipe. Yeah, some of them do so like. What's it? Oh, yeah. Right, yeah, it's Johnson's case, they got.
Okay.
Right. This last case is not. Everybody have a great holiday weekend.
Thank you, you're all done?
Yes, sir.
All right, have a great one. Enjoy your long weekend.
Thank you so much, Sean. You too. Louise as well. I don't think you can agree with you too. Thank you.
Hey, Judge. Have a good weekend. Thank you. Take care now.
Is the next person?
No, yeah, yeah. It was hard.
Mr. Robinson, yeah, I just wanted to, I just got a really great work date.
Okay.
So. I know, but yeah, check in and stuff like that. Is my prosecutor? Has any playing witness for New York show up? Huh, fabulous. I'll be out in the hallway. Thank you. Say, take it all.
Yeah.
Good morning, Judge.
Good morning, how you doing?
I'm okay, how are you?
I'm well, thank
It's a lot colder outside than I thought it was going to be.
you. Yeah, today and tomorrow is supposed to be good day. Edward Robinson? Yes, sir. Okay. Calling case 2455153, people of the state of Michigan versus Edward Robinson. Defendant is charged in count 1, criminal sexual conduct, first-degree personal injury. Defendant has an official offender, fourth offense notice, mandatory 25 years sentence. Appearances for the record.
Good morning, Your Honor. Sonam Mobsisian on behalf of the people, P83923. And my last name is spelled Mobsisian.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P55470 on behalf of Mr. Robinson. Mr. Robinson and I are physically present in the courtroom. Mr. Robinson, please state your full name for the record, nice and loud.
Edward Martinez Robinson.
There's the date, time, set for preliminary examination. Are people ready to proceed?
That is correct, Judge. We are not at this time, and if the court will allow me to give an explanation for that. So I don't know if you recall, our complainant in this matter resides in New York, and we have had extensive contact with her back and forth. And we bought her a plane ticket. She got to the airport yesterday. Unfortunately, her circumstances are very different. She does not have a state ID. We were unaware that she did not have a state ID. So when she got to the airport, she did present other forms of identification, including like her EBT card, other things that had her photograph on it, her lease, things like that. She informed me that they did give her ticket at the desk, so she was able to essentially check in her bag. Her bag had all of her other identification stuff that she put in it. The bag got sent. The bag made it to Detroit. She did not. She was not able to go through the pre-check because she did not have her state ID. She didn't have any of her other documentation with her, so she was stuck at the airport.
What happened to the documentation that she gave her to?
It was, for some reason, she thought that that was the only time she needed to show her identification.
She bought the ticket in advance.
We had already got the ticket for her, Judge. And so when she went there, she showed them the email essentially showing that she had this ticket. She showed them the documentation. She put the documentation inside of her luggage. That luggage was checked in. And so she did not have that on her. And when she tried to go through TSA, they did not permit her to. She informed me that she was taken upstairs. She spoke with several supervisors. She told them why she needed to be on that flight. She missed her flight because of essentially all of these extent, like,
She could put her on a different flight.
and they could not put her on a different flight because she did not have her IDs. And then she couldn't get her ID because it was in her, or her other forms of identification were in her luggage that essentially made it to Detroit last night. She did not.
How did she get to New York in the first place?
Judge, that is a good question. I'm not sure. She's been living there for several years now. This case is from 2022. I believe she left here several years ago. I will say she's very dependent on state funding in New York. She was homeless when she was living in Detroit. That's actually how she ended up meeting the defendant in this case, was because she needed a place to stay that evening and shower, and the defendant offered essentially his apartment for that evening. Her circumstances in reality is very different than ours, and now, of course, understanding that she doesn't have a state ID, we will be working with her to get her here through different means. What I will say though, Judge, is this is someone who is very involved in this case. She called me twice last night, twice this morning. She has spent hours on the phone with our victim advocate. New York police have been in contact with her there. Our officers have been. I mean, this is not someone where it's like, we don't know where she is. She's very involved in the case. It's just a matter of, unfortunately, getting her here was beyond, I think, the circumstances of what we would have expected. And because of that, I do think that it's just cause for endearment, just given the difficulties that she had at the airport. And I don't believe that she is in a good position to be able to advocate for herself at the airport, given the difficulties.
So what's the plan moving forward?
So Judge,
essentially,
we probably look into getting her a Greyhound ticket through a bus. We have to figure out how to get her stuff back to her because all of her documentation is in her luggage that's currently in Detroit. But we will look at other forms of transportation to make sure that she gets here, even if it involves that victim advocates here getting her a license of some sort. I think we will do what we need to. But there are other forms of transportation.
How long is that going to take?
I think the first step would essentially be getting her here on the bus.
How long is that going to take?
That shouldn't take very long, a few days, if that.
Yes.
Judge, if I may ask, what airline was she originally booked on?
Delta.
So, Judge, I'm going to make a motion to dismiss, and these are the reasons why. One, and I know the court has flown. I fly Delta primarily. And I know that when you go and you are checking in bagged luggage, they are not letting you put anything else in there because it's getting weighed. They're going, they need a photo ID to go and look up. Even if you have a physical ticket in hand, they need to go, like your printout, they need to go and still look it up in their system. They need to tag the bag if you had not already done it. And they are checking. And I know, I've just flown actually early last month. They are very efficient as to making sure that you're not touching that bag once it's on their weighing scale. If that anything has to go in there or be taken out, it is under their direction, not you doing it on your own volition. So I find it a little bit hard to believe that all that documentation that she showed them to go and get the bag checked in at the counter before you get to TSA security to go past that point to be able to get then to the to get to the airline where it's departing. I find that a bit incredible, just based on my common working knowledge of traveling by plane, especially by Delta, and their and what they what the place the protocol that they have in place. Judge, I don't think that she was intending on coming here, and I would just be very surprised with this version of why she's not here, why Delta, under those circumstances, if she had talked to everyone that the prosecutor has told us that she was given that information that she had talked to, that there wasn't something that was even being able to make even for this morning. Because from New York to here takes what, about a little over an hour and 15 minutes. I think we get one drink service and that's about it. And then we're touching down. And I believe she's in the in one of the boroughs of New York City. So it would either be LaGuardia or one of the other two airports that are in that Disney. And I know they're very good about trying to reschedule, especially under circumstances like that. I find that a little difficult to believe that they would not be able to go and rebook her with those extenuating circumstances.
So you think that she would go through the trouble of going to the airport and send her luggage here?
If it is here.
Did not come?
I mean, do we have that verification? I don't know if the prosecutor never said that they spoke with the airport or the airlines or any of the people that the complaining witness said that she did speak with yesterday.
Do we have any verification that the luggage is here?
Judge, my victim advocate actually, as we speak, is working on it to get her luggage back to New York.
So she has verified.
I don't know if it's been verified, like I can't say that because I don't know, I haven't done it myself, but I don't see why she would say that, knowing that we told her, I talked to her this morning about trying to help her get her luggage back. She was so concerned that all of her documents are in this luggage that is no longer with her. Tiffany Mueller. She's literally in the office doing that. Before I left, I asked her to follow up with Delta to see what luggage essentially back on an airplane sent back to New York so that she has her her stuff. She paid $30. This person paid $30 to have her luggage checked in. It's not an accurate representation, I would say, of what counsel stated as to how this works. We buy the tickets, she does not. We buy a non-refundable ticket. It's not always available to change these tickets. Unfortunately, that's just the parameters in which our office works in. She tried to show them all of this information. Unfortunately, they were not willing to help her in other ways. I have flown myself multiple times. I know it's very possible, and I've done it before, where you are allowed to put whatever it is that's in your hand into your luggage that's being checked in. That is not an issue. That's not incredible to believe that that happened. Again, we're dealing with someone that doesn't necessarily have the same, I think, exposure and experiences as we do, or even the fact that we did not know that she did not have a state ID.
All right, given all the circumstances, it does appear that there is good cause to adjourn. February 23rd, gonna be enough time?
Say that again, I'm sorry.
February 23rd, gonna be enough time?
Yes, Judge, can we do it again, similar time as to today, later in the afternoon, just because I have a few hearings up in the morning?
I can do 12 o'clock.
We can do 12. I hope that I'm done in Frankfurt by then, because I may possibly still, oh no, that trial should be done, but I do have 4 other matters and I'm house counsel at 2 floors.
12:30.
12:30, that would be a little safer.
All right,
Yeah.
12:30.
Thank you,
Court
Judge.
finds good cause for the adjournment. I will adjourn it to February 23rd, 2024 at 12:30.
Thank you, Judge.
Yes. Okay.
You have it, right? Oh, yeah. So maybe what I can do is share with you those details and then we, you guys can move on or you'll get through this work schedule. Okay, yeah. Okay, sure.
Well, folks, that concludes the document for today.
Yeah.
Hope to see you Tuesday next week. Monday is President's Day. We will not be open. So hopefully Tuesday, same bad station, same bad. Enjoy your long weekend.
Yeah, enjoy your week.
Thank you. You too now. Not yet.
Okay.